Um, I was thinking about the Criminal Damage Act and this part which says it shall not be misconstrued as a defence against a charge if you're exercising a right, privilege, and interest. Well, we know about privileges. It's not a defence or a plea entered. It's something that you claim before entering a plea, and it has to be recognised through the overriding objectives. And also, you can have a right or an interest if you do have it. This is like a valid claim to it. You're not arguing it or trying to prove it beyond reasonable doubt, or you're not entering a plea. There's no crime to answer, basically. It means there's no crime to answer in that court. You don't enter a plea and say that I didn't commit the crime, or admit that you did commit the crime and it is a crime. It's that you don't have a crime to answer effectively, right? You can have this right, privilege, or interest. Now, I wanted to explore that, and I wanted to type in around 1971, 1972, 1973. I thought if I find a law book, like a book they were using at school or at college, or at university, when they're learning that Criminal Damage Act when they first enact it, I thought if I find a law book, a textbook, a study book of the Criminal Damage Act from 1973 or 4, it might help clarify the interest. Off the top of my head, what I actually think the interest is kind of like I said, if you've got a sofa, right? If that's your sofa and you own it, you cannot be charged for criminal damage of it because you have ownership rights over it. And if you want to change it, modify or damage it, it's not an offence. There's no crime to answer. You don't plead that you're guilty or not guilty of damaging your sofa, because you can't plead guilty or not guilty, because either way it's your sofa, right? And how you prove that is you're not pleading not guilty to a crime and using it as a defence. Why? Because it's not a crime. It has to be a crime, and then you have to prove that you're not guilty of the crime, right? If it's your sofa, right, you don't have to you're not proving that you didn't commit the offence, because proving that it's not a crime is not proving that you didn't commit the offence, okay? Or you're not guilty, but of the crime, because it cannot be a crime. It can't be a crime, okay? It's not possible to be it if it's your sofa. So you can't be charged with the crime, and you can't be guilty or not guilty, because now how would you prove that? Well, you prove ownership. How would you be in a situation where you had to prove ownership? Well, I don't know. It depends whose sofa it is and what house it is. But put it this way, the receipt of purchase is a certificate of ownership, right? That's an example. If you pull a receipt out, okay, you might have forged the receipt or so forth, but if you pull out the receipt, right, you're not what you're doing is you're showing a certificate of ownership to the court, right? And that is that you have the rights over that sofa, okay? But you don't have to prove that in defence of a charge or answering to a crime, because you're proving that it's your sofa and it cannot possibly be a crime, and you're proving that there's no crime to answer. There's no crime to answer for to anyone because it's your sofa. There is no crime to answer to anyone, right? And this is like with the privilege. If you've got jurisdiction of Parliament and it's not for that court to hear it, you're not guilty or not guilty. You get it actually says this in the Parliamentary Papers Act 1940. It says that you get a certificate from the Speaker to show that to validate your jurisdiction of Parliament. But if you can show that, if you've actually got a petition live on the website, I don't see why you need a certificate from the speaker, because it's like a certificate. It certificates authenticity by it being on the Parliament website and it being yours, right? It's enough to prove it without needing a letter from the speaker. That's like a right and a privilege. That's an example of a right or a privilege where you cannot. There is no offence being occurred, and there can't have been if you've got a certificate of ownership and purchase of the sofa, okay? And you don't have to. You're not actually trying to prove that to a court through giving evidence, entering a plea, giving evidence, and having determination by a jury. Because if you pull the receipt out and it is recognised and validated of ownership, then there cannot be a crime to answer on that sofa of its damage. Now, why does it say right, privilege, or interest? Well, I would say that this is my opinion, right? This is my opinion. They've used interest in there where they've included a right, privilege, and interest, all three of them, when you don't have to answer a charge or enter a plea. I think the interest may be that if you're at someone's house, right, that I've given an example before, like if you spill accident, if you have an accident, basically an accident, you spill wine on a sofa. Now, this is the thing. It might have damaged the sofa. So how do you say, well, it's damaged the sofa. So, if there was a police officer at the party, right, and this police officer, is just being awkward, right? But this is what the law says. If he's like a robot, officer that's programmed to respond to things, but not that intelligent, and he's just going by directives, he might say, well, the sofa's been damaged, so I'm sorry, madam, you'll have to go and fight it out we'll have to take you to the court to determine it, right? If you've been invited to the house, and if you've been invited to the party, and you've been asked to sit on the sofa by the host, and he pours you a glass of wine, and you're sat on the sofa, and you accidentally spill it, and everyone there kind of like, agrees that, it was an accident. Well, why doesn't the law kick in and say, okay, this is an offence has just happened. How can you have a right, privilege, or interest in it not being a crime to answer? Well, I think on that, because you can't prove ownership of the sofa, right? In that instance, you can't pull a receipt out and say it's my sofa. If you were in front of a court, okay? And if you don't have any privileges, like you're not like Lord Pumpernickel sat on the sofa, you can't claim parliamentary privilege or whatever, or peer privilege, right? But it was an accident, right? Let's say it was an accident. You didn't do it on purpose. You didn't intend to damage it. But I think that is kind of where the interest sort of comes in, because at least in that pre-plea context, because if the owner invited you onto the sofa and you had an interest to be at the party, you were interested in the party, and then you're interested in the conversation, and then you were invited to sit on the sofa, there's no ownership of the sofa there in law, but you had an interest in being at the party on the sofa, drinking wine and talking to the host, and he invited you there. You're interested in his conversation, and therefore all of it, you were acting in your interests, and if it accidentally spilled the wine on the sofa, then I think that is, I think that counts. That it's something around that for it not being a crime to answer. It's permissible under you had an interest to be on the sofa at that time drinking wine. And it's not an offence to answer a crime, because otherwise then you would have to prove, you would have to enter a plea and go through the rigmarole of proving to a jury that you had you get into this lawful excuse. What was the lawful excuse? Or well, I was invited to the party, and he gave the wine to me, and he asked me to sit on the sofa and talk to him. And I wasn't looking what I was doing. You're having to go through all these arguments, right, and defend the charge. or even that you were acting honestly and you didn't do it on purpose. But even then, even if you honestly were under the belief that if you held the glass in that position, they wouldn't have tipped over. But if somebody else walks past, now this is the thing, all of that, whichever complicated technical legal argument you want to go through, right? You're still having to enter a plea and answer a charge. That there's got to be something where it's not an offence. I think if the owner of the sofa with the receipt, who is the owner of it, says that I invited this guest there on my oath and I had interest in the conversation, right? And it's okay about the damage, I'm not too bothered about it. You see, sometimes the police can press charges, sometimes even if the victim doesn't want to press charges. I know my friend had an argument with his girlfriend and there was a charge, and then they said, oh, they don't want to do it anymore. The police carried on doing it. The police said, oh no, there's a crime here, and they pursued it anyway. So if the law mechanisms continue or carry on for whatever reason, I think that they can, the person can say, it's okay, it was an accident and invited them in. There was an interest there, therefore it's not even a crime. I think there's provision in that for that. A lot of these modern lawyers, I don't think they're taught this properly. The Criminal Damage Act is a different act. It's different to a lot of other laws because you've got all these things like, you've got these situations where you get people looking around houses if they're interested in buying them, or if people are invited onto. It's a law that it's almost kind of like this kind of like civil law, like you owe me some money or I owe you some money or whatever, because if someone spills on their sofa, they could end up taking it through the civil law. If people are at a council meeting, they're around at the council and they're doing certain things, you're inviting people onto property or people coming onto property. The Criminal Damage Act, and there's a lot of people in the public arena, which is public property, not necessarily private owned. It's an act of law which has a lot of convergence of civil scenarios with potentially criminal things can happen, but it emerges a lot of civil scenarios, but possibly even political. Now, what I wanted to clarify was that word interest. So I think also in this, I found this. I've got this open and I'm looking at this, but this is quite important because I was looking for a book on Criminal Damage Act, but I happened upon this, which is some Hansard excerpts from some lords in Parliament debating this high-profile case, which is quite funny because I think that when we were watching the Petitions Committee and Theresa Villiers, they were talking about the ULEZ fines, and then one of them said, oh yeah, we're not going to talk too much about the legal case or the legal matters because it's ongoing. And they said, oh, I think they might have hinted that they might have possibly been able to talk about it if they'd have opted to, but apparently they didn't. But they were trying to make out that maybe they shouldn't talk about it, or maybe they couldn't. But there was some slight inkling that one of the chairs of the committee might have been able to give some sort of order or command what they could talk about it. But this is great because this is a debate in the Lords about criminal law while there was a case ongoing, I think, in the courts. And this is like 2005, right? So this is 2005, way before all this Extinction Rebellion business, when you've got some of these other cases. This is a little bit like Keir Starmer acting pro bono and, acting for protesters who are climbing up things and painting things, but then it gets pulled away from the CPS. It's not Starmer, but this is earlier than all this Extinction Rebellion stuff. So this is around 2005 sort of time. to do with one of these wars, right? You know, when there's a war going on, it may have been Blair or whatever, but oh no, 2005's Gordon Brown kind of a little bit. So it's sort of like, you know, I think it's kind of like, you know, the backside of the Labour government, but to the point, they're sending tanks overseas into a war, right? And some protesters chain themselves onto the tanks, and they're protesting about sending tanks and military things to war, right? So it's a little bit like what Extinction Rebellion are doing now. So what Extinction Rebellion are doing now isn't anything new. So all this Priti Patel legislation with locking on and all this, they're actually dealing with that like in 2005. And the result, they're resolving it through all this and talking about it, right? And they are actually talking in quite a lot of detail about the ongoing legal cases and the legal matters and things. So they definitely can do that in the House of Lords, and I would have thought the Commons as well. So I don't know what all that tosh was about in that Stop ULEZ case. But anyway, and there's a couple of, I think there's a case on at Southampton and one at Cirencester or something like that. But then they ended up appealing it to Bristol, I think. But what's happening here, right, is they talk about the interest, actually. Now, the word interest only appears twice in this whole excerpt here, right? So he's saying that in order to protect property belonging to himself or another, or a right or interest in property which was or which he believed to be vested in himself or another at the time of the act is alleged to constitute the offence, he believed that the property, right or interest was in immediate need of protection. Right, so that helps a lot. I don't think I'll need to get the textbook out for the interest part now, because it's like, so okay, so like, let's say a hay bale's rolling down the road, okay, and it's going to crash into someone's house, okay. Like a hay bale falls off the back of a farm lorry, and the hay bale's rolling down the road, and there's like people diving out of the way, maybe it even goes over someone's bike and crushes it, and then the hay bale rolls, and let's say it's going to roll into a nice white wooden fence through someone's garden and, you know, hit the side of the house, right, or something like that. It's not your house, you don't own the house, right? The house there isn't yours, right? You don't own it. It's someone else's, and you don't have any like receipt or proof of purchase or anything like that. But you might like the house, or it might be your friend's house, and it's like, you know, like when you're having a glass of wine, I said earlier, on your friend's sofa, right? You know, it might be your friend's house, or you might just live on the street and you might like the house. It might be a pretty house and you might like it, you know, and it's in the interest of the public to protect it, or your interest to protect it because you like looking at it. You could have the opposite of this, where someone might really not like someone's house and they might buy it and demolish it just to piss on the bonfire. Or, you know, the double glazing man might come around and write off the entire village as vintage windows with, you know, PVC ones. You know, he might have strategized that, put adverts on all the TV to coerce them like the Pied Piper or whatever. But, you know, we won't go into that about affecting other people's interests and taking control of people's interests through mobile phone adverts, through mobile phone apps, trying to charm and arrest people's interests and change them so everyone buys a conservatory. Things like that. This is what's happening now with all, by the way, big time. And that's what the food do. The food get people's interest. If we build those McDonald's and, you know, Subways, and there's a waft of nice smell of baking bread going through the air, you can arrest people's interests or attract them over to the food, right? And then you might change the instead of changing the property, you might change them. You might change the weight size, so then instead of them all being, you know, size 8, they might be size 16, you know. You might have intended that, you know, to, instead of changing a building, changing people, you know. That could be criminal damage, but, you know, maybe that's stretching it a bit far, but I'm just kind of painting the picture around the edge of this interest thing. So go back to the hay bale, right? this actually happened to me while I was doing my investigation campaign. Loads of crazy things happening like this, which are questionable. There was a big hay bale somehow ended up in the middle of the road that had rolled somewhere. Oh, it was in the newspaper, wasn't it? Anyway, so right. So what can you do about it if you see if you have the opportunity to act because you're a little bit further down the hill and when it happened you've got a little bit of time, right? So you might do something. So if you had like a van or even maybe a loader truck or something, you might actually be able to reverse it into the middle of the road to stop the hay bale rolling any further. Okay, to stop it rolling into the house. You know. Or you might have to even, you know, reverse the truck, into the garden to stop it actually hitting the wall and going through the wall. That's just a random example, right? But that's the interesting operation, right? That's just an example of the interest. Now, according to that Criminal Damage Act, that aspect, that element of it, can be. It's one of the three factors, or one of the three reason fact. Well, a fact is a fact, isn't it? It's a fact. The word factor is like something that is true and fact. So you've got your three determining factors that can prevent it from being construed or regarded as a defence against a criminal charge. Okay. So, so you've got your right, privilege, or interest. So that's like ownership, that you own it, or privilege, like you there's a certain other jurisdiction or authority in place, or interest, where, it's almost like an invitation. I think the word invitation is interesting because with if it's inside a house and a party, you've been invited into the circumstances and something happens. It's almost like you've been invited under the right of the owner, but it's not actually your ownership, but you've been invited to, kind of like into their ownership. And then same with the house, you've kind of invited yourself into the situation because for a good cause, for a good reason or cause, to help prevent or protect something. So that's the interest. But sometimes with interest, you might be looking around a house that you might be going to buy, but there's still an invitation involved because there's an invitation from the estate agent. Even though the estate agent doesn't own the house and you don't own the house, but the estate agent's got the keys and they've been invited to ask you around because they've been given administrative responsibilities, and they invite you to look around it. So all those, that's why the Criminal Damage Act has got these in it, because it's the act where you've got scenarios where there's people or persons who are engaged or active in or about other properties that they may or may not necessarily own. Okay, and there are also privileges which may or may not come into effect, because there could be casework and causes like the police. The police are an authority, and so forth, a fire brigade, things like that. So it is quite an interesting act. But so you're in, I think, with the interest, if you've been invited, in connection with the owner, or if you've invited yourself with some goodwill or so forth, there definitely is no crime there. And with the privilege, there might have been a crime, but the crime's not there with that court at that time, that jurisdiction. I've just read something about the Magna Carta, which has helped clarify a lot. So, Thomas Erskine May talks about the Magna Carta in his Privileges of Parliament book, and he uses Magna Carta and the Bill of Rights. Now, what I've found is that he's got that from just before Sir Thomas Erskine May's time. There was this Lord Denman case after the burning of Parliament, and they did all about privileges and publishing. Actually, they'd agreed that if it wasn't for profit or business or commerce, then it was actually already protected. But it was the fact that Parliament was selling the Hansard book or selling papers from Parliament, and there was some business or commercial activity in it. Otherwise, the defamation or harassment actually would be under the jurisdiction of Parliament for sure. So it wasn't actually disputing the fact that there was defamation. It was because it was in connection with business or sales. Now, in some of in those Parliament sessions, which is what I'm reading now, there's quite a lot of material out of that session of Parliament about it. There's a lot of material to read, but there was some publications put out: the Edinburgh Review, the Quarterly Review. We're all talking about privileges and Parliament. Now, that was just kind of like just before Erskine May. So what Erskine May's been looking at and reading when he did his book, because he was Clerk of Parliament, remember, or Clerk of the Commons, whichever, and he will have got that from somewhere. Well, obviously he worked in there, but I've just read a piece, and it specifically talks about the Magna Carta and in context to the Bill of Rights, so that's what I think. That's where Erskine May's got that from. The sequence of time fits it, and the subject fits it, and he's in Parliament. You know, it's his circles of people, and the exact publications that it would be available and would be quite new, and what we'll be looking at around that time, and of the period. So I definitely think Erskine May had read that Quarterly Review and the Edinburgh Review, which I'm reading now, and also the sessions of Parliament as well. So that Sir Thomas Erskine May mention of Magna Carta and the Bill of Rights is from these 1847 material I've got here. There's no doubt about that. That's, you know, it's clearly obvious. And what they're saying is that how they talk about the Bill of Rights, they're talking about it like it's the new constitution, effectively. The Bill of Rights, how they describe it and how they refer to it in their language and dialogue, is that, the Bill of Rights, 1688, that's the new constitution of England, right? And this is Parliament talking. So they're like, this is our new constitution, and what they were saying is that they'd never had any problems with defamation or harassment or anything published by Parliament. They actually said that it'd done really well for 150 years without any problems. They said, right, we had this constitution in 1688, and now we're in 1840s, and it's done really well. It's held up well for all our privileges, or it served its purpose. We haven't had any cause for scrutiny on it. And obviously, like Parliament burned down and had to rebuild it, I'm starting to wonder how many defamation cases might have arose in those petitions, should they have been published, the ones that never got read out in Parliament, all the claims of causes and offences or grievances and so forth. Maybe that's why they burned them. Maybe that's why Parliament was, burned down, or maybe they did. We don't know for sure, but, it begs to question what material would have been held in those. Is the only have all the original Parliament session books been destroyed, and do they only survive because of Hansard? Is Hansard the only reason why all the earlier sessions of Parliament we've still got them? Because they, through the 1600s and 1700s, they were publishing them and making them available, right? That could be the answer to one of my other questions. But anyway, so Magna Carta, they're saying that it's based basically on this, that the oath of the peers and the judgment of the peers, and they had all these Privileges Acts way earlier, but it's definitely meant to be this, the complaint, the grievance, so to judgment, effectively, on the oath of your peers. So when you've got a complaint of a crime and you get a arrest warrant, or you get people who are allowed to pursue the criminal, it's all going to go to court anyway. So this is the thing: whatever force you use to apprehend the criminal, or whatever, if any damages occur, you're doing it in a process which is already so to judgment. You are intending to go to judgment. You as well. You will all be before the court. The complainant, the plaintiff, and the accused, the respondent. You are going to court, or you are going before judgment with peers, and in fact, the peers are even helping. So it is intended to. And that's the thing, it is intended to process, due process. So you're raising or calling due process. So anything that's done within that due process that you called is to be judged on, including your own actions. This is the thing. If the police arrest someone and whatever, and something gets broken or they hurt someone, so to judgment. You meant to call it out in that court there and then. I know there are actions against the police, and usually people do those separately nowadays. But really, if the police, usually I think these actions against the police are civil, and if it's a criminal cause, I think that's the difference, because you want to claim money from them, but damages. But in terms of criminality, if anyone's criminally liable, you're up in front of the court. So, you say, there, no, he punched me in the face. That's an offence. But did the police use reasonable force or not? The exceptionally high-level good lawyers who, if you give them a lot of money, rather than just, scrimping and scraping to manage to get you off, with a not guilty charge or whatever, it could thoroughly, have mention hearings, case management, other matters to address in the thing. There are many things you could have, but how much money have you got? How much is it going to cost? Most of these lawyers are like getting there, like done and do the job. They just want to get in there, do the job, and get out. As economically as possible. They don't want to mess around in there. With multiple crimes and offences on the police and so forth. And, this is the thing. It's so to judgment, you're before the court, and with that set of circumstances. If the police did commit crimes and they get away with it, this is the thing. This is the law of the police. So, but that's what it means. It basically means so to judgment. So all the things that you are doing are going to go to judgment. But this is the thing when it's with Parliament, because you've got the right to bring a case to either House of the Parliament or the King. And remember that, why does it say that? They didn't always used to have Parliament, and Parliament's not in session all the time. So when Parliament's not in session all the time, the King and the Privy Council are there. Or if they didn't have a Parliament, like, within the long and short Parliament, that's the reason why, because, there might not always be a Parliament. So, there's always the King, though. That's the thing. So Magna Carta, yeah. So, the interest, so the public interest, it's in the public interest, to apprehend the criminal. So this is a thing, when they shout out hue and cry, and everyone in the village, if everyone in the village doesn't apprehend the criminal, that they might get fined. So it's in everyone's interest. It's in the whole interest of the village to apprehend the criminal upon sight. If there's a warrant out for them, or so that's interest as well in criminal. So you've got interest in criminal. You've got an interest in criminal if that is the cause that is raised. But if it's on the oath of witnesses to Parliament, to petition to stop the war, then you could say that it's in the public's interest. You could say that, 100,000 people have signed it, so that there is an interest there. So you've got a right, Parliament jurisdiction, privilege, and interest, right? So there's public interest. So for the Criminal Damage Act, you can have the privileges of Parliament, the public interest of 100,000 people who have signed, and therefore they're right, And there are rights in multiple acts, There are loads of acts with rights in that come into play, like the control of advertisements, Copyright Act, section 1911, section 20, various other rights, but they're all built around those. So with this Criminal Damage Act, that's what I wanted to look into, this interest. So immediately the public interest, I didn't think of that one with it. So, action in the public interest. And the public interest is surely the interest of the jury as well, you would have thought. But when it's written down in oath and people have signed it, it's to judgment. So that's kind of like the introductory part. Hold on a minute. So now I'm just going to type a different word into the search, not that interest. Right, so now, after all that, we can actually get on to talk about this piece here. So this, like I said, is some dialogue of Lords talking about this case around 2005 when people are locking on and chaining to tanks, okay? Now this whole piece here, it's not that long on this webpage that I've found. It goes to that's the bottom there, 64. It goes from, it's only an excerpt, 33 to 64, right? What it basically is, what's actually going on in this bit of writing here, is that the Lords are debating like these crimes of these protesters, right? It's a little bit like a kind of 2005 version of this whole issue that they've been doing with Rishi Sunak and Priti Patel and the Extinction Rebellion lot and the Public Order Act kind of. But this was similar kind of thing, but in 2005, before anything had gone to the extent that it has now. There were some protest groups, but I don't think they were always getting in the news, or it was nowhere near. The national situation was that there were some protesters groups, but they just weren't getting the publicity or interest as they are now, and a lot fewer of them. They hadn't got anywhere near the momentum of like Extinction Rebellion or Just Stop Oil, but they existed, like Swampy and the Bypass. People knew about them, or protesters, or hippies or whatever, but it was a lot smaller groups, and usually they had this scene which was based around Newbury, Glastonbury type, kind of southwesty sort of. It attracted. This is to do with Charles as well, Charles got into the whole environmental thing. Anyway, so what they're actually doing here, right, is that they are arguing around the actions of these protesters, and they're talking about the case, and they're talking about the legal arguments that the protesters put up in court and put forward, that, they were actually. So this is, I'm sure that Gail Bradbrook has probably read this, or if not, this is probably what you call a very good example of a case study, which is going to be the basis around how they've been doing this in modern times, at least after the miners' strike period and the 1980s, right? And what this is like, basically, this is like, you've got your Good Law Project, Joyland Morham, and you've got Tim Crossland, who's, doing law for activists, and the current thinking of these lawyers who are currently engaged in these cases for these activists, and the activists themselves when they've been doing reading up on the cases, and Gail Bradbrook particularly, her way of seeing it and understanding it, this fits. This would be an example of really what's happening now with, or even when they get acquitted, even when these activists and protesters get acquitted, like some of them got acquitted recently in Manchester, right? Some of them are getting acquitted, but they're putting in defences and pleas and arguments, and whether there's a lawful excuse or whether it's common law or and so forth. And this sets out a lot of the bases around many of these arguments when they were handcuffing themselves to tanks, or if they're acting to prevent a war. If it's an actual, it's also raised. This is really important for Extinction Rebellion now when they're going about peaceful assembly or peaceful protest. They're saying that if you're acting to stop a war, it's an act of peace. Okay, so if two armies are going at each other and you stop one army from proceeding forwards, like handcuffing yourself to it or stopping it, that's peace, an act of peace, because you're preventing war. That's one of the arguments, or at least the basis of the argument, right? But then you've got lots of other complicated and very technical arguments around, all the intricacies of what constitutes the damage. And then they've also got, are they preventing a crime? Is it a crime? They explored, is it, in another country, if people getting killed or shot, due to a war, is that a crime? And can it be regarded as preventing a crime from another? If you're in England, can you be regarded in law before a court as preventing a crime in another country? All that type of argument, right? All in and around all that. Now, what is interesting is, firstly, we've got, if we zoom right out and look at it in what it is, it's still protesters and it's still government, because it's Ministry of Defence and sending military to war, which are those tanks are the property of the king, but it's meant to be like the country, the taxpayer. It's taxpayer. It's not a cornflake factory or McDonald's, right? The tanks are the military of the country, right? So it's the property of the king, but it's state. It's like taxpayer money, right? So it's not private. Now the thing is, that's whether we should go to war or not, and acting to somehow stop the war, is matters of church, state and law. It's a matter of church or the state or the law getting the law made or changed. Maybe we should make it illegal to go to war, but it's state. It's a matter of state. The government directing the army. It's affairs of the nation, right? It's Ministry of Defence, right? So it's matters of state. Ministry of Defence, and it's declaring that we're going to send military forces over, or should we not send military forces over? That is a matter of state. Okay. Now this is the main point, I think, to do with this and every single case that really is under scrutiny at the moment, like Julian Assange, because if it's a political issue, he can't be extradited for his political opinions and views. If you're publishing something and it's political, you can publish it. Also, this Tommy Robinson, this Yaxley Lennon, Tommy Robinson case with his political film that he showed in public, which that's a matter of state, because I think he's wanting some action to be done about it from the government. He's even got a material out called manifesto, which is what you do, when you governments put out manifestos. So it's, if it was just a normal crime, it would be pursuing it to the police only, right, to try and get charges against this other thing. But he's raising it to the state, saying this is a national problem, basically, right? And it's like my investigation, you could say, well, illegal road signs, if it's been done on purpose, that's just a crime, but not when it's done in every county in England, all around the country, and all these police are getting their equipment from the same place, and it's organised. It's like a racket, so, it's institutional corruption. It's a matter of state, it's more than the totality of the investigated matters are more than for one magistrate or Crown Court in one county. It's a matter of the whole country, right? Like my investigation. So it's this matters of church, state and law. And I think the tank thing in the military is a matter of church, state or law. Now that's the main ignorance going on in this matter. It's the main ignorance going on. Because for matters of church, state and law, like under the Tumultuous Petitioning Act, right, it is not a local regional issue. It's a matter of the whole country. Now, that ties into the privileges and the public interest. So you've got privileges, interest, and then also your rights as well. So that is rights and it's rights and interests. Okay, rights, privileges, and interests. Now that's not getting acknowledged at all. Now the difference is, so that this tank thing and handcuffing yourself to the tanks, that's matters of church, state and law. And the Criminal Damage Act, really, if you are, there's a lot of things in that act which have got nothing to do with matters of church, state and law, or right, privilege or interest, right? You've got bank robbers, you've got just vandals. You've got, estate agents, people going around looking at properties. You've got normal accidents and incidents in the public sphere, like, fire, police, ambulance, just in a local area. But you've also got accidents and incidents that happen, like I said, with that hay bale rolling off something and rolling down the road, and that's just an accident that happened, but the public might need to act or do something in the public interest or in the interest of the person's house who it is to protect it. That's not a matter of church, state or law to the government. What happens if there's a fight at an O2 arena with Oasis, right, and the police said that it's not safe on there, and they throw everyone off, and people want, there's a lot of drunk people, and they want to get back into the music concert, right, and there's 50,000 of them, and they're all at the edge, and the police put a dispersal order, and there's 50,000 Oasis fans going, we want the show, we want the show, we want the show, we want the show, and they get signs up, and they write them out, and they get the scarves, and they go and let us back on, and that's not a matter of church, state or law. That is a protest. And this is where Resistance GB and, GB News, Double Down News, Navarra Media, all these news outlets and groups and people, and Extinction Rebellion and Just Stop Oil, and all the scene of all this whole political rights or, article, whatever, freedom of expression, where they're getting it wrong. Right? And with the miners' strike, picketing, right? When they are outside their place of employment and they are complaining to their employer about their wages and refusing to work, and they're actually asking their employer to get their wages higher or they won't go back to work, and they protest outside the business premises, and they might get a bit rowdy and rip some fences down or sabotage the loading bay or something. That is not a matter of church, state and law to the government of England, right? That is a protest between workers and an employer. That's picketing, right? Although the word picketing actually means to protect and defend with a pitch barrier or ditch, right? So the actual real word picketing in the English language means to put a defensive protective area, where you could say maybe around Parliament from the public interest. If everyone in England suddenly was annoyed with Parliament, they might have to put up a picket around there. That, the police defending Parliament, that's the true word of picketing. But it got picked up and used for basically for the miners' strikes and so forth. So the miners' strikes
That's protesting, right? Now, the problem is that what's happened, and we're getting on to the point now of this whole piece here that we're scrutinising, this dialogue in the House of Lords, which is 2005, is that they're in denial and ignorance of the issue between this particular protest against the military going to war is not a dispute between staff and employer. It's not a dispute between a arena and some punters who want to listen to a music gig. It's not a matter between, a random incident in the street where there's a hay bale rolling down the road and people might have to act to protect property in a local area of jurisdiction. It's matters of church, state, or law where we shouldn't be going to war, right? And that really vexes the authorities, because really that cause and the public interest who under oath oppose it and write to the government and petition and object to it is actually under the jurisdiction of Parliament, not the local courts, right? Particularly, I think there probably were petitions about that as well in writing, and that's the difference. And this is the thing. The other element is the Criminal Law Act 1967, Section 4, assisting offenders, where anyone who's aiding or helping, the police supposedly to apprehend a criminal, particularly if the Attorney General authorises it, they're acting in the interest of the public to apprehend the criminal, and they're actually helping. This is like, an answer to judgment, but depending on what authority or jurisdiction the judgment is originally arose under and is attending to go to, you've got that. There were some arguments in this about, were they trying to stop crime, by handcuffing themselves onto tanks, were they trying to stop crime or offences or people from getting killed, right? But now you're getting into the territory of this whole, what about the O2, when they were trying to protect the forests and trees and the protesters were going then. Is that against an employer? Is it a protest against a private music gig, or is it just, an incident that's arose in the local area of its own incident? No, it's actually the government's project to do O2 and people opposing that and trying to get Parliament to stop doing it, right? And protecting those trees, what are left. Now, that is also like this chaining yourself to the tanks, because it's a matter that's to government. The trees might be owned by a certain landowner or company, and there might be a contract out from O2, but the project itself, like Stonehenge Tunnel, that's a matter that they're disputing with the government, right? And this is when we're getting on to the argument of damage and breaking things or protecting things. Are you protecting something? Are you trying to stop damage from happening? Extinction Rebellion's whole argument of, the planet's being harmed, the people are being harmed, all of the Extinction Rebellion and Just Stop Oil arguments about the environment and the planet, which they're putting in court and having to defend themselves and argue, right, is like this thing with the passing on to the tanks, because most of the time these causes are being put to the Parliament, and it is a matter of what they're wanting the government to act in with a certain amount of public interest, and it is meant to be under privileges, and this is the difference. Now, in this act, in this page here, we've got the dialogue of the Lords, and they're talking about it. They're talking about all these arguments about protesting and picketing, and they're saying certain things. Now, what they say is, here, they're talking about a very old and ancient, obscure authority. Or what might that be? Well, in 2005, they'd already had their peer privileges repealed, and I think it was 1948 or sometime, the Scots had, but they didn't repeal the Magna Carta, but they claimed they were repealing the privileges of the peers, which I don't think that they did, because they didn't repeal Magna Carta. And then 9 years later or so, they actually repealed Magna Carta in that Criminal Law Act, I think it was, actually in the repeals. But they'd said that they'd taken the peers' privileges 9 years earlier, but they'd only repealed this Scottish Act thing. So either they were going about it very slowly or very cautiously and carefully to see if they could get away with it. They said it was unnecessary. But even without the privilege of peerhood, we're talking about Parliament peers, you've still got the privilege of Parliament, which is, if you're doing working peers in Parliament or MPs, you've still got the privilege. They've still got the privilege of Parliament, but it's not the privilege of peers. Now they're saying that they repealed the privilege of peers, but they've kind of done it in 2 stages over 9 years. I think they're testing the water because apparently you can't repeal Magna Carta, because of the confirmation of the charters. So I don't really know if they had a little bit of a test at it to see if anyone grumbled or complained. You'd have thought all the peers would grumble and complain, but they still had the privilege of Parliament. So they've still got the privilege of Parliament to rely on, not the peer privilege. And then 1948 and then 1967, right? Which is what I've called them out on, because the whole time afterwards they've still been opening Parliament with all the ancient rights and privileges. So their own ancient rights and privileges have been unlawfully messed around with and repealed under great scrutiny and question when they're still opening Parliament with all ancient rights and privileges, right? So even the Lords and Barons have been kind of conned and swindled, or they've gone along with it. So you've got to think, right, in 2005... you're in the House of Lords, you've got the peers who have sort of had peer privilege repealed over 9-year period a lot earlier. So now they're even questioning ancient rights and privileges here as being obscure, some obscure possible ancient right or privilege. Well, it's not obscure when I'm reading all about it now in the actual petitions. They're actually using it and talking about it. It's far from old and obscure. That I think when they talk about ancient, old, and obscure, they might be trying to think of, like Jesus Christ or something, or even earlier, like 500 BC, or the dinosaurs. It's not that old and ancient when they've got a printing press and there are multiple people writing about it, letters to Parliament in great volumes and numbers, and there's multiple acts of legislation, like the Privileges Act itself, all through the 1620, 1700, it's far from obscure and old. There is voluminous and extensive material on the subject in frequent use. It's not kind of like Excalibur or Merlin or Robin Hood. It's sessions of Parliament discussing it on record, and people writing letters about it and in frequent and common use. So it's they may need to question themselves. So that what they're doing is they're actually revealing through this dialogue here that there might be some other factor in this whole thing. And this is exactly the point I'm on now. What I'm trying to tell Extinction Rebellion and Just Stop Oil and the Good Law Project, and Black Belt Barrister and other channels and people. I'm trying to explain to them, look, right, you're doing all this peaceful protesting and all this, convention rights, freedom of speech. But there's something you're missing here, right? Because this is not like just a crime. It's not like, normal crime, and it's not like, it's not really protesting without a just cause, or protesting without a pre-existing jurisdiction with the government. It is different, and they're trying to ignore that. Now, they're talking about the word obscure. I think the word, they're obscuring it. Obscure, the word to obscure something, it is someone's got to be obscuring it, like obstructing something. Obstructing something is blocking something from happening. obscuring something is making it difficult to see, understand, or know. But in the same manner as you might obstruct something, you might obscure something. Now, you could use the word obscure in its own context. Like, it was obscure, just, it was self-obscuring because, a page can be obscure if it has faded from the sun. If a page is faded, right, and it has become very faint, it's been obscured, but it might not have been intentional. It might have just become obscure. If this is the thing. Now, you can have a person who is acting in order to make something obscure by redacting, withholding, keeping secret, or failing to mention informations. They're obscuring it, right? Just like you can have a natural obstruction by a rock or boulder being somewhere out of nature, that obstructs it, or someone, like the Rolling Stones, someone could put something there in order to obstruct it. So it can be being obscured on purpose. Now, they're admitting here ancient and old obscure law. Well, that will be, they know very well what they're talking about in this dialogue. They know there is privileges, they know that there's a jurisdiction of Parliament, and they know there's a public interest in matters of church, state and law, which in the Tumultuous Act are defined, which you can petition to either Houses of Parliament for a resolution, and that removes from local court jurisdiction, particularly of the judgment of your own peers, particularly if your own peers have signed an oath, petition to investigate and to act on something, or to call for action, and so to judgment by Parliament. So this is what I'm on with now. I've been focusing on and researching and learning about what they refer to here is old, ancient, or obscure law, where it isn't that old, ancient, or obscure, right? They're trying to make out that it is, or they've been obscuring it. And the fact what's obscure is, these are matters of church, state, or law of the country. They're not matters of a local theft. They're not matters of a protest about being on a rock concert. They're not matters of, protesting, picketing an employer to raise your wages, or you're not going back to work, or even damaging the factory if he won't raise the wages, right? It's different. And that is what they're obscuring. They're obscuring the matters of church, state and law with these tanks and going to war and handcuffing on them. And effectively, it's a 2005 version of Priti Patel's whole locking on affair with Extinction Rebellion, right? And Gail Bradbrook. Now, really though, there are also... You had similar incidents with the suffragettes and with the Luddites, right? It's nothing new, really. In fact, the Luddites, you might say, well, why didn't they want the Luddites just smashing up machines randomly, and weren't they arguing with their employer, right? Weren't they like a bit like miners striking? Well, some of Arthur Scargill and the whole miners' strike, there were actions and negotiations with government going on. But all of the physical protests were regarded as picketing, and they were regarded as a dispute with workers with their employer, between a worker and an employer, workers and a private party. That's how they were trying to frame it, basically, right? But the Luddites actually was a petition to Parliament over, a massive, huge petition to Parliament for the time, over minimum wage. Because they wanted the minimum wage raising. And Parliament said no. That's what the matter was originally about. And what they did is they turned to attack their employers, right? Because of government not doing it. Now, that's not attacking government tanks, owned by the taxpayer or the king, or whatever you want to say, right? That is actually private premises. Now, you can say Extinction Rebellion are attacking banks and McDonald's and so forth, right? So it is a little bit like, you have kind of got a situation like the Luddites, and some of them were hung. And this is what Denman defended some of them. But they actually stopped prosecuting them later on, and I think the last one was in Nottingham. He got sending like a threatening letter to his employer. He dropped off a threatening letter, delivering a threatening letter. But that was apparently the last charge. There was no more prosecutions or charges after that. And then over the next 50 years, by then, or whatever, by the time that Luddites thing had phased out, by the end of that century, they got the Labour Party for the workers, who haven't actually really done that much because we're all skint still, and the cost of living's gone through the roof. So, now, these are the arguments of Denman. So Denman was trying to defend the Luddites, They didn't bring it under privilege at the time, what the Luddites were doing. It could have been, though. They were petitioning, but they started to turn it against the actual employers. Now, this is the thing with Extinction Rebellion, but they have got a cause, though. The difference is that the Luddites have got a cause to Parliament, but they wanted a resolution, and there were people sworn to it, an oath, and really, was that a matter to the government for resolution, and were all the activities and actions arose out of the public interest? In a way, it was sabotage, really. I'm not trying to say that helped them further their case. It was almost like, trying to rebel, demanding, the wages changed. I don't think the suffragettes went to that extent. They were just basically trying to collect signatures, raise awareness. I think, that woman ran out in front of the king, tried to put a sign on his horse, she got run over. I need to look more into the suffragettes part of it, but I don't think they actually went around smashing machines up, right? But the tanks, I think the main argument is, right, if there's no cause, right, there is absolutely no possible right, privilege or interest to raise at all. If there is a cause to Parliament, and if the matters are under that umbrella, then this is these ancient rights and privileges, and they're actually suggesting that, you might be able to, but you see, this is the thing, if you're apprehending a criminal, what force can you use to apprehend them, right? This is the thing, the police are breaking doors down. The police are saying to people, I will hurt you, I will apply pain to you if you don't do what I say, right? Now, that is a model of and so to judgment, right? The police are shouting and so to judgment before a court, right? And we're doing what is necessary to do that. And also to prevent any further crimes from happening if they have reason to believe that it's a crime. If the police are acting wrongly and they're doing things that they shouldn't be doing in order to prevent crime or apprehend people, and so to judgment in front of the court, right? Now, this is the basis in matters of church, state and law with an existing cause that has been put to the Parliament. Is what the people are doing too much, too extreme, too far, right? Shouldn't they fasten on to tanks? But it is a matter of church, state or law, and it is under matters of Parliament, and it isn't in the local jurisdiction of these courts with these people's peers, because their peers have consented to petitions and signed it and said, and so to judgment at Parliament, and so to judgment. And, anything that they're doing or claiming to prevent trees being cut down in order to save those trees or postpone any further damage is only really, to any philosopher or any deep thinker, they know that if a police officer is stopping someone from his face getting smashed in and repeatedly punched, right, and he's physically intervening, that is a crime happening, but there may or may not be other things happening which he may or may not should or should not be intervening in, right? But that matter will be, if anyone questions that, it will be questioned at the court, right? And this is the thing, when no other court, if it is, that is where it's going to. And the things with Extinction Rebellion just stop oil and stop ULEZ and so forth is that they have got a cause, and to what force and arms or effect is required is meant to be under the jurisdiction of that authority under Parliament, which is in matters of church, state or law. And that is what they're obscuring here. And they're treating it, really, what it comes down to is, it's being treated as if it's a load of people going berserk at a music concert. And we get into damages and protesting. And they've done this. They've done this example on Doctor Who on that 73 yards or whatever program when they've got everyone off the football pitch with our machine guns protecting it. But why? There's nothing there. But they've got that MP going on speaking. Isn't it always dangerous at those places with all those people? How come football matches don't have armed guards like airports if there's 50,000 people assembled? You'd have thought that that was the most dangerous place ever. People. Could assemble outside Parliament, but they're not. But they've still got armed officers around there, right? So, they're obscuring this matters of church, state or law that have been put to Parliament and not under the jurisdiction of a local magistrates court or Crown Court for sure, right? Now, this is the thing, with that injunction that Tommy Robinson broke, Yaxel Lennon, they've sent it to a Crown Court to deal with from the High Court because he broke an injunction, right? Now, they might say, well, Parliament can refer it to a court or defer the matter to a court. Yeah, but, in a lot of these cases, they're not. In a lot of these cases, right, Parliament haven't issued an order or command, or not what we're aware of, to do that. It's just the police turning up, saying, oh, there's crime here, we go to a court, right? Parliament didn't say, oh, this is a case with Parliament, but then we have a meeting or a committee to say, oh, we'll refer these matters to Crown Court Magistrates Court. I don't know if they can or not, because it's a privilege, isn't it? Or if they're waiving privilege. But, have they summoned any of those activists there to give evidence? This is the thing. Or are they giving secret? It's almost kind of like this Parliament have been telling this 77th Battalion or Brigade to take certain channels and videos down, but which ones want a privilege. But the thing is, you've got a right. If Parliament are asking for 100,000 signatures, right, and you to collect those signatures, if they're stopping you from collecting their signatures, that's illegal because. Right, Parliament might not have to hear the petition, but you've got the right to petition and collect the signatures. And this is like where the no man's land point of this is, where like the invisible line is, or where the area of kind of obstruction or obscurity is with the petitions committee in Parliament, right, on the online part of it. They'll let you collect 5 signatures, right? Everyone could collect 5 signatures, right? And write out the petition. So you've actually done it. They haven't stopped you from doing it. But then it had to be published, right? And a lot of them they were rejecting. But really, you've got a legal right to collect the whole 100,000 signatures without being stopped. Because that's the right to petition, right? And they were obstructing that, which is illegal. So there was some, and they also didn't really let you write much thorough information which could justify or prove your cause, trying to make it so you couldn't put information on there. So it was really quite unlawfully done, that website, really, because they were kind of saying you could do it, but then stopping you from doing what they can't stop you from doing. They were stopping you from doing what they can't stop you from doing. And also the thing, when it's published, what I think is, like this whole Magna Carta and the, answer to judgment and officially write the complaint out, I humbly showeth, that's the form and manner of a petition, which is exactly the same as the affidavit, right? And once once you submit that to Parliament and it gets checked and they publish it, like a lot of the ULEZ petitions were published, that is issuing it. And you know, like when a police officer goes for a warrant to get a warrant, right, and it's authorised, right, all those petitions that did get published and did get authorised, they had been basically given warrant to run, right? They couldn't really stop you from collecting the signatures. They were kind of like doing the reverse of the Tumultuous Petitioning Act 1661, which was effectively, right, that act said that you can collect 20 signatures, right, but no more unless you get consent. Okay? But that's been repealed. So you didn't need consent to collect more. But Parliament was almost kind of like trying to do something like the Act, where they had to give you consent to collect more than 20, more than 5 or 20 signatures up to 100,000. But that's been repealed. You didn't need consent for that anymore. But you shouldn't need all those signatures. I mean, 20 maybe would be enough. Now, the problem is that they're actually asking and demanding and encouraging this voluminous number of signatures, right? They're actually saying, right, because in modern times there's a lot of people wanting the government to do things, they want it to make it difficult for you. They want it to make it extremely difficult to get something debated in Parliament, or to make it a real challenge. So they actually wanted more and more and more and more people to sign. Like, we want 100,000. So they're actually encouraging and wanting more people, which is quite the opposite of the Tumultuous Petitioning Act. Although they were kind of really behaving in a similar way to the Tumultuous Petitioning Act, the Tumultuous Petitioning Act never demanded, it was actually encouraging less. The Tumultuous Petitioning Act was discouraging more signatures and more supporters. Parliament was encouraging, if not demanding, more signatures, right? So it's the opposite. And then what Parliament are doing, though, is even though they've been commanding and demanding these extraordinary numbers of signatures, they're actually then annoyed and being pissed off with the fact that when they do get these large numbers of people supporting these causes, it's a mess to deal with, because they've got all these Extinction Rebellion and Just Stop Oil causes causing havoc. But they're the ones who demanded and commanded large numbers. So now they're making them all criminals, or trying to. But they can't, because if they've got a matter of church state law in the first place, then they're not seen as a criminal if it's for that cause. And the right to petition says that, you can't be imprisoned or arrested or criminally liable for matters of church state of law that are in the public's interest. And all this damage that's occurring is only civil damage. Now, this is really, with these tanks and so forth, handcuffing onto tanks and so forth, really, these protesters should have been civilly liable, not criminally liable. Maybe even the Luddites. Maybe Denman didn't put a good enough argument from the 1688 Bill of Rights and the Claim of Right Act Scotland. Maybe Denman should have, when he argued this, he was meant to have been a very good lawyer, but he wasn't that good at arguing cases. He was more better at making law. Or I might have got him mixed up with Pollexen, but anyway, I think he could have argued, instead of those men getting hung, I think he might have been able to argue that they're not criminally liable at all, because it was in matters that arose from those petitions to Parliament, and even though they did cause damage, they would have to pay for all those machines, which would have been difficult if the minimum wage hadn't been raised up. But there is an argument that they shouldn't have been hung, that they should have just been made to pay all the damages for the factories that they damaged, and possibly even that guy in Nottingham who dropped off a threatening letter, and maybe they could have had a civil damages for upsetting them or whatever, but not criminal. That's that's possible. I think Denman could have argued that. But the fact is that we've got this piece of writing here, and what it's saying is it's it's playing with us, it's toying with us, it's jossing with us, and it's mentioning, oh well, there might be some kind of ancient rights and privileges as well, but they're a little bit obscure, and it's all in the past now. Seeing the half of his peerage privileges written off, must grumble. And by the way, don't mention the words church, state, or law. This is just a protest. Maybe it was Lemmy. Lemmy from Motorhead used to have tanks, didn't he? Lemmy from Motorhead used to have like loads of tanks and military things. He had to have he used to have battle reenactments. If Lemmy from Motorhead is dead now, but Lemmy from Motorhead, right? If Lemmy from Motorhead had been, on his own private estate, having a battle reenactment, what if the protesters had come across it and thought that there was a real war going on, and they jumped in there to try and stop and chain themselves to Lemmy's tank, right? And tried to stop him from, having a war with, Jeff Rowley or something, right? And, having a play fight, but it looked like it was, actually firing, live ammunition. I don't know, you can't have an armed tank, can you? I don't think you can get licensed to have an actual armed tank, even if it's on an estate for fun, unless it's in another country where it's legal. But, okay, let's say they've got, well, you can have some weapons. Whatever weapons you're allowed to have by law, anyway. Maybe they're just pretending to have a fight, or maybe that could be considered dangerous, or putting people at the risk of danger or harm, unless they're just like complete and totally A-team, fully. It just it's what do you call it? It's not live ammunition. It's just like the duds or whatever. They just like spark and it looks like it's firing or whatever. But the protesters could say that they could be opposed to aggression or something, and chain themselves to Lemmy's tanks just to stop him being violent. They might not be asking the government, to intervene or do anything about it. It might just be the fact that Lemmy is having a battle reenactment, and it's not it's not peaceful. They could chain himself to that, but they might be protesting against Lemmy himself. Being a celebrity with squandering excessive amounts of money on pretend wars or something like that. But it's not a matter to the government. Unless they say, wanting to actually ban weapons or get the law changed, but I don't think they were. This actually was the government's tanks, real tanks and real weapons. So this is the thing. Now there is another thing in this as well, besides this obscure ancient law, which is this is on point. The part that I've highlighted in orange here around this obscure and ancient law, which they acknowledge, that is like the situation that I'm in with like Extinction Rebellion, Claire Farrell and Gail Bradbrook. They're like playing this by the book. Gail Bradbrook and Claire Farrell are like playing the whole thing, and Tim Crossland and Good Law Project. They're playing the whole thing by this kind of dialogue, effectively. They're playing the rule book by this, how it's being presented. And it's not being presented, as it's just normal protest and a normal convention rights. But this is the thing. When you get to this part here, oh, what's this? Well, there's some obscure and ancient laws, and it might not matter what excessive force you use, because they also talk around the fact that there might not be any limit on the force that you can use or the actions that you can take, but that may be very old, ancient, and obscure now. Well, this is where I am. This little bit of dialogue here, just a minute, this is ancient, obscure, and old ancient law here, where actually it might not matter what force you may or may not use, because it's not under that court's jurisdiction. This is what I'm trying to introduce to these people. This is what I'm trying to say. Hey, look, there's some obscure and ancient law here, but it's still law and it's still in effect, and we should be using it. So this is exactly this whole little piece here of the Lords talking about this in Parliament. They are aware of it and they do know about it. But remember what I said, they've had their own peer privileges ripped and stripped from them unlawfully by charlatans, or maybe they consented to it. Maybe they like allowed it to be taken from them when it's been done unlawfully as well. So really, they're kind of a little bit in the same situation, you know. And there's another part in here that I'll need to mention, which is they talk about another act of law which there was an ancient distinction between a felony and a other less serious offence, right? So what they're saying is that there also were felonies which are really serious offences, and then there were just like, you know, normal demeanours, crimes. And then what they're trying to say is, in some of the, I'm going to put the link to this, by the way, as well, you can read through it. What they're saying is that certain acts of law were introduced in more recent modern times which removed the distinction from between the felony and the normal misdemeanor, right? But isn't that the entire basis of a summary offence versus an indictment? Because you're only indicted and you have to go to the higher courts. It's more serious with the circuit judges of the king. If it's an indictment, well, weren't those the felonies? Now, I'm not an expert or professional lawyer, but I know that if you've got a separating dividing line between misdemeanors and felonies, right? And in a felony, they can apparently take your things from you, but not in a misdemeanor, like your chatels. Then why? When was the felony used? Well, I'm sorry, but wasn't the felony the matter that had to be put to the assizes or quarter sessions, or to, you know, Westminster or whatever? Wasn't that the point? And wasn't that because it was an indictment and not summary? So, forgive my lack of education about the ins and outs of it. There might be some other obscure dividing lines and divisional qualifications in and around that. But generally, wouldn't the average person of the normal layman or moderately informed citizen assume that the difference between the misdemeanor and the felony was the pivotal difference between the summary offence or the indictment? Now, if these lords, now I'm not saying I'm right about that, but I need to raise that, and this is what I question. You know, I can't read everything at once. I've got this privileged stuff to read. I can't read everything at once because too much. But I assume, or I think to say, I'm fairly confident that surely it would seem ridiculous or strange to introduce a law or legislation which remove the ancient separation or definition between a misdemeanor and a felony. Because why have the Crown Court? Or why have the Magistrates Court? Or why have an indictment and a summary? Because aren't you really saying there's not really any difference between a summary offence or an indictment? If you're going to say, well, we'll just get rid of the ancient difference between a misdemeanor and a felony. Isn't that generally more or less somewhere around what they're saying? Unless there was a particular specific reason why they wanted that definition of felony versus misdemeanor to not exist anymore. But they still, why would they still want, you know, summary and indictment to exist? You know, they still wanted people to be indicted for serious crimes and only have a summary offence, for lesser crimes. I think that's really important with the driving offences, you know, because, you know, I said that, you know, police aren't allowed to hold pleas, particularly if it's a felony. You know, you've got to have a fair trial at a court of record with a jury, or it has to be either a court of record or you have to have a jury, right? And magistrates' court doesn't have a jury, neither is it a court of fucking record. None. Nothing. So, this old police chief not holding common pleas, well, if they repealed Magna Carta and then they got rid of the difference between a felony and a misdemeanor, does that give the police license to, just take confessions off people and crimes? Well, but why have, indictment and summary? Now, this is important to my case because when I was up at the magistrate's court, she said, even though I was having a privileges claim in a separate civil hearing, right, first, even though she said, when you go to trial or if you go to trial, do you want it to be dealt with summarily or indictment? Well, that was a weird offence because the dangerous driving charge, ironically, unlike the majority of offences, it's a special offence that you can say, well, it can be either or. You can either have a summary or indictment. But most summary cases have to be dealt with between 6 months, and they took ages. They took over 12 months to sort it out, which would be over the time of a summary. But then when I end up in court, they say, oh, well, do you want it dealt with summarily or indictment? I'll say, well, if I have it dealt with summarily, then can I say, well, you're out of time then, please? Because if it's, now it's summary, I'll decide, I'll say, now it's summary. I'll have summary and see, no, you're out of time because you took 12 months for it. Then I'll go home now, so I'll see you later. Oh no, well, it had the potential to be an indictment, but because it had the potential to be indictment, then we could take as long as we want. It can take 10 years to investigate it. All right, well, we'll decide, what we want to mess around with, but, well, how can the police decide that they're not sure, but then give me the option and say, oh, I'll press the button. You can press the button, whether it's summary or indictment, but we get to decide whether we take 12 months or 6 months over it, which if I'm pressing the summary button then and saying, oh, it's going to be summary, then surely can't I write off the 12 months that they say, well, make your mind up. This is the thing. Now, that summary indictment thing is it a misdemeanor or is it a felony, really? But they wanted to get rid of the difference between misdemeanor and felony. But they haven't, though, because they've still got Crown Court. And they've still got indictments. Why didn't they erase all knowledge of summary or indictment offences and only have an offence, right? And a sentence, depending on, what it was. Some of them have got prison sentences, others haven't. But they didn't. They've still got summary and indictment. So it just seems insanely ridiculous for whatever their own reasons are. But also, if it was a felony, to take your if you can only take your driving licence off you if it's a felony, then you can't have. I don't think you can have an indictment at the magistrate's court, only Crown Court. So it matters actually with things like driving licences, which are possessions, not community service or paying a fine. It's actually taking your livelihood off you, your ability to work, like your car, which they couldn't take off you Magna Carta. It's like your livelihood. It's actually, a driving licence is a thing, an object which you possess, right? So I think that that's, I'm not saying that's the reason, but it's one of a number of reasons which would figure into this, why they might have a desire to get rid of this ancient distinction between felonies and misdemeanors, and police chiefs holding common pleas and getting confessions and it not being a court of record and not having a jury, when losing your driving license is quite serious. So you do get the privilege of going to a magistrate's court if you rack up 9 points, but they're still taking your driving license from you, and that's felony, and it's not a court of record, and there is no jury there. So really, it would need to take an indictment to take your driving licence off you, surely, because it's quite serious if you lose your entire profession. But they're not bothered because nowadays they don't think I've trained 50 years to be a cobbler, like Keir Starmer's dad. My dad was a toolmaker. He learned how to shape tools over 50 years of skills, and it's his lifelong profession. But we chop his hands off because he's a cunt, or whatever, sent him to China and chop his hands off. Now he can't make any tools. That was the verdict. You cannot be a toolmaker anymore because we chop your hands off, right? That's an indictment. they took his livelihood from him, which they can't do at a summary or magistrates court. Well, I'm not saying that you should chop someone's hands off, but that's just an example of a joke. But to take your driving license, it's your skill, right? Your skill, right? You drive, but the police don't care. They're just like, they don't really care that your skill is driving, and in fact, they think that your skill's bad. It's poor skill. It's almost kind of like you've been making dodgy tools which are no good or faulty, or the standard's very low, therefore they're not going to let you make tools anymore because you're rubbish at it, They don't care. The courts don't care. They don't care. They're like, the livelihood is literally... It's not like, they don't see it like, you're a blacksmith in a village, there's only one blacksmith in the village and so forth, so forth. I think you can have certain arguments if you're an academic and if you're a professor or if you're a professional person and, or a lawyer and you've been doing pro bono, they might actually exercise, special reasons or whatever, which you can have special reasons, by the way, it turns out. But I think that, effectively, it's nothing, get a job sweeping the floor, it's like that, it's like they don't recognise that you have trained or a skill set and it's a livelihood and, even your driving license is an object and they can't take that off you. They just think that, you're just a peasant and you're doing one job and, now you're going to be doing another job. They can, change your whole... thing. It's a little bit like not being able to go on holiday. What happens if you want to be a travel agent or an air hostess, and what happens if you did a... I mean, I don't know whether I can go to America because of that, although it wasn't dealt with as an indictment, so I don't know, because it was dealt with summarily, it might not ban me from going to America. But if there is an indictment, you criminals, Americans don't accept criminals, so it affects your livelihood if you're an air hostess or something, or a pilot. If you're a pilot and you fly planes and you go overseas or whatever, and you fly planes to America, and you get done for a crime, that's going to take your livelihood from you, isn't it? I'm not too sure if they can do that in a magistrate's court. But then again, magistrates' courts don't normally deal with indictments, do they? They only deal with summary offences. But this is the thing, things like that affect livelihood. But when it's driving, they just, they really... Police chief, literally, it's like, there's someone's dropped a pin on the floor, or, there's like a crumb. I was like, who's put a crumb on my desk? Like, just flick it away, like, oh, where's a fly squatter? You don't care. Although, they think it's a serious matter because of all the serious accidents and injuries on the motorway. But we're talking about in legal terms, in law, they're not bothered, and this is the thing. So, there's some dialogue in this about them when they removed the ancient differentiation between felony and misdemeanor, which I just think it's almost insulting to intelligence. Really, what the final conclusion that I've got is, if anyone can follow anything that I've said, is that it seems to me that they know what they're talking about. They're being coy, or they're the ones who are being obscure. They're obscuring the truth and fact and full extent of the law. And I think that they're almost like a prototype for Priti Patel, in that they're trying to disillusion, or that they're trying to cover up or hide this matters of church, state and law, and its jurisdiction, and its pursuits under law, and the right to do it. And there is protesting which does not fall under matters of church, state or law. It exists. And what they want to do is they seek to blend and merge it all together, and hopefully this ancient and obscure law, which is the privileges and the fact that you actually have a cause or case, not unlike assisting offenders, with immunities which can be granted, complete and total immunity can be granted under that, and no matter what force you use. They're wanting to, hopefully, that people forget it. It's not that ancient and it's not that old when I've got a computer folder here with 120 examples of it in use in the House of Lords, and I've got the Sessions of Parliament written up in only 1840, 1840, sorry. In the 1840s, of full and complete intellectual academic dialogue of members of Parliament and pamphlets and leaflets being put out in the quarterly, edition and Edinburgh Review, which Thomas Erskine May based his book on, which Parliament are still using now. So it can't be that old and obscure, particularly in that chapter XIX. Thomas Erskine May talks about privileges, and he also mentions the Magna Carta and, Bill of Rights. They're making it obscure by not wanting to discuss or talk about it. And I actually, so they're trying to, with the whole protesters issue, I think they're just trying to, it would almost kind of like, blending this, indictment and summary, blending that together, through this offence that can be either or in a way, could well, if you can say a dangerous driving charge could be either or, it's summary or indictment, you could say that, handcuffing yourselves to tanks could be parliamentary privilege or not, either or, depending on if you have it or not, if it is a matter of church, state or law. Because you could have a gang of, you could have a lot of drunk football hooligans walking out of a pub, having a laugh, and then just, saying, "Oh, that tank's going to war," and having and kind of like handcuffing themselves onto it, or even throwing bricks at it and saying, "Oh, all that war business, it's a load of tosh," and throwing at it, and then going back to the pub again. They might not be actually seeking to pursue anything. It's almost like either or. And at the end of the day, you're up in front of the court, you've got to claim your rights and so forth. And the thing with Extinction Rebellion and Just Stop Oil is they have been doing political causes to Parliament. It is a matter of church, state and law or law. They have been trying to get Parliament to act in things. And, the argument is over those powers. But we're not arguing those powers. But instead, what's happening is this entire piece here is doing this. He's arguing it as if it's not the other. The either or doesn't exist. And that's the problem. Extinction Rebellion have been doing it as if this other little thing exists, because maybe it's a little bit too ancient or obscure for them, except for people who get very interested in it, when it actually turns out that there's a lot more other things to be interested in, like what are the MPs doing on TV providing entertainment? Why are the judges breaking their oaths when it's still in the oath? It's almost as do you know what it is, right? It's equivalent to what's happening now in the courts. They're doing these plea deals, right? That this whole plea deal issue is bang on the money, right? What they're doing is they're doing plea deals. Tony Blair introduced it. Thatcher and Blair sequentially introduced this because there weren't really any sentencing guidelines. So why would you need to make a deal with anyone if there wasn't some kind of, menu there to try and say, "Oh, do you want chips and a pasty or, a burger and fries?" Well, actually, I'll have a 69, please. Okay, then that's 5, please. Okay, then 5, please. There you go. This is the thing. They've introduced these things, right? Yet, there's this ancient and obscure thing, right? Which happens to say that you can't do deals for justice in exchange for justice, right? But, that might be an old and obscure law. Well, it's in the freaking oath of the justice that he has to take in order to do his job, right? He has to take the oath or he can't do the job. In fact, that's what makes him a judge, taking that oath, right? And it still says that can't do any favours for justice, right? So, it's not that old and obscure when he fucking said it himself and sworn to it. and he's still using it in court. It's the same thing. Oh, we'll do a plea deal with you, but just a minute, there might be some ancient and old obscure law that might have something to do with this. Oh, it's me fucking oath. I took it in order to get the job. Still in use. Ain't that old and obscure? I don't quite know what it means, though. That's what's obscuring the fact. I took the oath, but I can't quite remember it. And to be honest, I could have said, supercalifragilisticexpialidocious. I don't quite know what it means. That's interesting. The High Court judge in England, who's listening to very serious, complex law cases, which black belt barrister is, relying on the meaning of one word could tip the entire thing, and on the interpretation of the word or what you meant when you said it could, tip the whole case. But I don't quite know what it means. Or, the judge doesn't quite know what his oath means. Does he know what anything means? Is it that obscure and old? Seeing that, he might have only took it, like Eden Eardley only took his oath, might have only took his oath 5 years ago or whatever, It's not that old and obscure and ancient when he's still fucking using the cunt. So this is the thing, and this is exactly the same principle with Priti Patel, with this locking on thing. Protesters referring to... what they're really referring to is people who are kicking off of football matches who are protesting to kick back on again. We've been kicked off the Oasis gig, and they're all chanting, on with the show, and the police have cleared the area, right? And then the police might say, right, we're going to clear the area even more, right? Dispersal order, and then everyone locks themselves on to the seats. If everyone's in a football match, right, and then the players refuse to play, and go off, and then everyone goes fucking berserk, right, and say, right, there's get back on the fucking pitch, right, and everyone's kicking off, and then the police officer goes, all right, we're going to disperse everyone, and everyone locks themselves onto the fucking seats around the football thing. Then Priti Patel can go, oh, it's locking on, it's locking on, slide away, give it all you've got, this is it, it's locking on, isn't it? So there is no matter of church state law or privileges in use. This is the thing. But they're trying to make out that is the same as when there is a political cause of action to the government, which is different. And this, it's not really a new dispute or argument, because they've had this with, Luddites and suffragettes. Gail Bradbrook talks about suffragettes mainly, but I think now I've realised how important the whole thing is. In fact, now I realise, what are all these protests about and what's been happening over the last, 300 years. Just a minute. Oh, we've stripped, we've stripped the juries out of most of the courts, but we've let women in there. We've stopped people having a say in what happens to their area, and then we've stopped them having money, but it's all gone to these big corporate entities who've been getting permission to build everywhere, and it's been harming our health. So this is what's been going on, and then they've been taking away certain ancient rights and privileges which can't possibly be removed or taken away. And because, the must grumble lords and barons now taking it out on us by saying that we don't have any ancient particular rights and privileges, so that's pretty much it, and we've got Jeremy Johnson KC, and Aidan Eardley there, who's not meant to be allowed to be a barrister if he's working as a judge, so this is it, and the whole thing, this, can you have an injunction against the Parliament cause? And particularly when you're trying to get public interest, if Parliament are demanding 100,000 people to support something, then you might have to show them a film in order to convince them of show them the evidence. Things aren't all done on paper now. And in fact, when they when they at the time, they weren't actually they weren't demanding 100,000 signatures in the 1800s, even before Parliament burned down. You had to get permission to get over 20 signatures, so you wouldn't have really needed to publish the petition in the magazine itself, not kind of like publishing it, copying it online with its complaint, but you got to be able to share it to people to see it. They've got to be able to read the complaint to sign it, right? That's for sure. And even if it's not published, you still got to display the complaint in public to get people to sign it, even if it's not publishing. There was no need to publish a complaint or petition in the newspapers, even if I don't know whether it would have been accepted on separate sheets with separate signatures anyway, but you could have let them know that it existed, and then they could have come round to sign it or whatever, or gone to the town hall or whatever. But people weren't. They were being discouraged from getting a lot of signatures, unless it was. But once you go through the court, it's getting fully acknowledged in what you're doing in your case and cause. So it's giving warrant to go to Parliament officially with an excessive amount of people, which is like where your shampity comes in, because they are not then tenuously claiming shampity. The courts said, okay, there's going to be more people claiming this right or claiming acting under this cause officially, right? Which is, this is the thing with those online petitions for Parliament. If you signed it, it's not shampity, is it? Unless you're just signing it and you don't really support the cause. But why would you really sign it if you didn't really support the cause and you're helping them, just to get the fact that you're officially logged in, on oath. But then you've got other people. What about just ULEZ? An MP. There were multiple ULEZ petitions. They got given as evidence in Parliament committee. They got declared. An MP even said that she'd arranged the protest, which surely comes under the cause. There are people who haven't signed some of them. Right, there were some people who haven't signed any of them, but they were sharing them, right? And on the Parliament website, it says share this petition. So it's actually, that's Parliament. It's not a standing order, but it's directions. When Parliament give you directions, those directions are under the jurisdiction of Parliament, surely. So, it's giving directions to share it. So if you're walking around, with some flyers printed of it with the Earl on it, then you're acting under directions of Parliament, that's for sure. Even if you haven't signed it, you're still sharing the cause, you're helping spread awareness of it. You don't have to have signed it. Most people would sign it if they were going to share it, but you can act. That's not shampity. You're not like claiming to come under the parliamentary privileges for the sake of shampity, if you don't really have an interest in the cause for the sake of it. If you've got a massive box full of 10,000 flyers with a petition on it, because why would you have bought them to help them, and why would you be giving them out if you didn't really support the cause? It would be ludicrous. That's not just like a couple of youths walking down the road and there's a bit of action kicking off and they just pretend to the police that they're, we're with these protesters or whatever, or whatever, to get out of trouble. These are all these things have been discussed and debated. And what's obscure and ancient now is the fact that there are some very solid concrete arguments and debates over many of these issues. But now this pleading dumb, this hearing in 2005, there might be some kind of ancient and obscure laws, but I'm not quite sure they're too obscure. I don't know what they are, you lying bastard. This is it. They're not obscure and ancient. There is debate on the subject. There is dialogue, Parliament sessions on the subject. There are actually existing complaints on record on the use of this. it's not obscure or ancient at all whatsoever, you know. And what you find out when you read this dialogue of the Lords is that some of them are it's either the charlatans, where they're putting on a charade or a show, like it's pantomime, it's a performance. It's like on Goldfinger, you know perfectly well what we're talking about, Mr. Bond. It's both of us know perfectly well what we're talking about, Mr. Bond. This is it. But I see that it's necessary to remind you. Odd job. This is it. Both of us know perfectly well what you're talking about. Whoever it is on here in the House of Lords, to tell us somewhere. Anyway, might be at the top. I'll just pick a name out. It's taking too long now. Oh, Lord Hoffman, that'll do. No, Lord Hoffman. Both of us know perfectly well what you're talking about, Mr. Lord Hoffman, with your peers. But it is necessary for me to remind you of the... Well, that's it, innit? That's exactly it. Both of us know perfectly well what you're referring to, Mr. Lord Hoffman, with your colleague peers in the Hansard in the Parliament of England. But it seems that it's necessary for me to remind you. This is the thing. It doesn't take much reminding when Lord Emmons, got 100 pages on it, in perfectly clarified, justified debate. It's always, if you're under the privileges of Parliament doing a cause, then it's not harassment or defamation in the courts. It's solely for our judgment, but making money out of it, selling it. Printing it and offering it for sale as a consumer product, so it's two different things. It's different. But if you're running around with ULEZ, get Khan out, stop ULEZ and get Khan out. How can it possibly cause offence or defamation to the Mayor of London? No, but if they were selling it. Maybe, apparently you can get Blade Runners t-shirts now and get Khan Out sweaters, making some money out of it, stop ULEZ sweaters. But apparently, according to the Copyright Act and the Parliamentary Papers Act, apparently, Khan could have, that's it, isn't it? Because I think Khan might have been able to, on the basis of that Hansard, Messiah's Hansard versus... Stockdale case, then they could have said, Khan could have said, they're selling sweatshirts of my picture on, saying get Khan out or stop ULEZ or whatever, and they're making money out of it, and sue them, but it's okay for them to just have the banners, down the road in Tooting, for the, getting the local public to, not vote for me or to sign the ULEZ petitions, which, the MPs had been holding sessions about, but selling the, stop ULEZ sweaters, sign the petition, make some money out of it, but, if it's non-profit for the cause, but then, I've been keeping the money for themselves, but maybe they could get a certificate from the Speaker of Parliament, to say, I hereby give you permission to sell Get Khan Out sweaters. As long as it's not get Sir Lindsay oil out. You could all be selling sweaters with Sir Lindsay oil on, That would be something, wouldn't it? What if they do a petition to Parliament to get rid of the Speaker, right? But they're all selling sweaters, and they're not selling them just to raise money to advertise the cause. Maybe they're just keeping the money for themselves, Just have to write a letter to Sir Lindsay to say, here's Sir Lindsay, could you give me a certificate, please, so we can sell these sweatshirts saying get Lindsay out, to make some money, even though that it's in connection with our political campaign, though it's it's done under the privileges of Parliament, but we're making money out of it. That's more the argument which should have been had, not whether they can actually do it or not in the first place, if it's just to promote or advertise, to get more supporters under Theresa Villiers' petition, which got debated in the committee, whatever. But this is, this piece here has pretty much got everything in it that is under scrutiny, but no one's arguing it. That's the thing. What they're all doing is they're just kind of like, they've got this playbook now, and it's kind of like more like a policy, really. It's like, all right, this is how we're going to play it, as if it's okay. It's effectively like, they're trying to pass it off like, okay, right, everyone, all lawyers, we will treat these as if it's a football match protest, when it's not. That's the thing. It is not. And no matter how many technical arguments you get here, they're arguing all the technicalities are coming out here, but they also happen to be mentioning lots of things which are relevant, which also have got great questions to be raised about the matters, like indictment versus summary, and felony versus misdemeanor, and whether it's a court of record or not, and should the police chief be taking pleas from everyone, which is amounting to a driving licence has been removed, and should the plea deals be being given again? Should bargaining for justice be happening when it's against the oath still, which is not really that obscure or ancient, when they're still got to say it and speak it, in fact, that's the dispute. The judges have said the oath, and it's still in law. They've done it. We're trying to work out that they haven't done the oath. It's almost kind of like, them arguing with the protesters, do you have a political cause to Parliament or not? And is there a petition? Have you signed it? You used to have to take an oath to go and vote, and to say that you hadn't received any gifts or promises of rewards or office or anything like that in order to give your vote. And Rees-Mogg, not give entertainment out to people, including his own electorate, providing entertainment which had been paid for even also by someone else, and get to know Rees-Mogg, let me entertain. It's like Robbie Williams, let me entertain you as well. I can't be on a news programme. Well, no, I can't present a news programme, but I can give you the news. But the reason why they had those news programmes is because there wasn't all this coverage of Parliament now. To be honest, because a lot of the sessions in Parliament are being covered and they put it out on their own Parliament channel, and you can see and hear what's happening in Parliament, and the Prime Minister has certain speeches or declarations, announcements. You don't really need MPs on news programmes to update you with what's going on. They don't need to be on there, really, because you can see what they're doing. Well, they never had that, you see. Back in the radio, they only had newspapers, so how do you know what your MP... No one knows what anyone's doing in Parliament. No one knew, right? So there had to be some kind of report in the newspaper to let you know what happened, or what law was changed, or we wouldn't know, or what they've done. It's in the newspaper, right? And then on the radio, and then on TV. But now the Parliament are doing it themselves, so you don't really need Rees-Mogg on there, just giving some news of what they've done, because you can see what they've done because you can listen to it while they're doing it. This is the thing. So really, you don't need them on there at all, unless there's an election, and then it's only meant to cover the election fairly without bias. But the election's not a surgery. The election is not a surgery with the MP. So you can't ask the MP questions, because surgery is provided by the government in an office which is paid for. It's not private surgery with a private company. That's going to a private doctor, and I think that's probably why they had Rishi Sunak on there. He's almost like a kind of private doctor or something. You don't have private sessions with MPs, or you're not supposed to. I know there's all this lobbying and so forth going on, but then they're going to do it through other people submitted to Parliament, not private companies or broadcasters getting involved. Input is through
official input provided by taxpayer, and output is through news reporting. They're allowed to, or there are certain things that have to be published if there's a road closure, or if they're doing all these certain things which need to and must be published and have to be and have a right to, which includes petitions, really. And this is when your YouTube channel comes in, which is supposed to be protected if you're collecting signatures and advertising. Really, it should be under parliamentary privileges, all the YouTube channels, which is what I'm disputing, and Public Meeting Act as well, even if it's not for Parliament. There's a lot of things, but this page here is just being, they are obscuring it themselves. They are obscuring it. They're obscuring the knowledge. They're obscuring the view. And whether or not they themselves might be somewhat uncertain, they've got access to reading all the material that I've got the access to read, and just look at them with their own privileges and rights. How can they, you see, that opening of Parliament with that Speaker petition and with the Lord Chancellor, that is like they're confirming all the ancient rights and privileges into effect and use and summoning the powers, right? You can't do that if they're repealed, because how can you use something that's not a law anymore? Or are they trying to make out that they've only got the privilege to do it? No, they're not, because they're their own privileges. So that's almost like the oath. It's what I'm finding like the same kind of thing going on. We've got the justices in court doing deals because they've been given these new dealing powers, which is against the oath, right? And they've taken the oath and said it, so that law can't be correct. And then similarly, we've got the very similarly, we've got the Speaker in Parliament summoning all the ancient privileges into effect, which is a little bit like the judge, doing the oath, but yet they've repealed the laws and they're not in effect. So in one instance, we've got an oath which is in effect with law which cannot be in effect because it's against the oath, and then similarly, we've got all the ancient privileges into effect and use, which cannot be if they've been repealed. But remember, there's the Confirmation of Charters cannot repeal them, and then you've got all these, Parliament privileges and so forth, and ancient rights and so forth, which you definitely use in order to do what you're doing, because it's the Constitution, and they're trying to make out that they don't exist, but they're still running the petitions committee, and they're still publishing your petition, which is literally giving you a warrant to pursue it, to further it. So there are a lot of incompatibilities being made, and perverting. This is a perversion of the course of justice, if there ever was one. It's also an abuse of the processes of law. It's also professional negligence. All of those. All those charges, and fraud, and forgery as well. Well, the forgery, because if you claim as a government to have repealed some of the privileges of the peers in 1967 and 1948, but yet your Speaker is doing a petition to invoke all of the ancient rights and privileges that have ever been into therefore use and effect, that's forgery, because he's either forging that petition, and it's a breach of privilege itself, and he's forging that statement, or he's committing a fraud, both, or the person who made the laws, it's a forgery. It has to be one or the other. And the enactments that Tony Blair's put through for offenders sentencing, that has to be a forgery because, well, you in a way you can make that law, but the justice cannot do that law because he's got an oath not to. So he has to. What the situation surely would be is that, if someone do a plea deal, well, say, I'm sorry, I can't do a plea deal. It's against my oath, and he stand up and walk out. That's happened before. If they know people, I know that man. I can't hear this case, so I'm not going to hear it because I know the gentleman, right? But the oath is set in law. It's not just an oath that he come up with and said, "Oh, it's my personal oath. I took this oath and I can't do that because it's my own. I swore it to God or to myself." The legislation makes the oath. The legislation sets what the oath is. Now all the oaths are made in law. So it's actually an enactment of law, not just an oath that is said. So the Tony Blair has made a law which is against other laws, which is incompatibility. And he's already been, suspected of war crimes, like anchoring himself to a tank or whatever. It's, something needs to be done about this. There are so many felonies here, misdemeanors, crimes. It has to amount to treasonous activity. It has to amount to evil acts, treasonous activities. It's and the perversion of the course of justice. How can you communicate this to the people without them being outraged? What would the military suggest? We've just had that soldier guy on that Performance Jets program asking, why is a kid holding a Nazi political banner when they're under the age to be prosecuted, even though if it's political anyway. He's asking, what should we do about this? What do you think about it? Well, what I ask him, what does the military suggest to do to this to resolve it if they can acknowledge that there's a problem? Like the A-team, what can be done? If the people are gonna go absolutely bananas, and if you do this procedure where they just don't admit or acknowledge it, but quietly try and correct it behind the scenes over an amount of time, this is when it becomes corrupt because they're not held to account. They're not actually held. This is the whole point of criminals. They're meant to shit their pants. They're meant to cry. They're meant to be upset. They're meant to be being punished. Although I've just read an act the other day where they repealed all these whipping acts and all these various capital punishment crimes. But crime has gone through the roof now. So you might as well say to the police chief, should we still have all these whipping acts and I'm not suggesting bringing back hanging, but hard labour, hard work, community service is not actually really regarded as hard labour or hard work, shoveling, or although you do shoveling there, but it's not like, are we going to see Aidan Eardley and Jeremy Johnson, shoveling coal or something, I don't know. Are they going to be put to building a new prison somewhere? This is the thing. Should we have had some of the more off-putting penalties? But there were laws against strange and peculiar sentences. When has ever the law used common sense? And this is surely something that Robert F. Kennedy Jr. should agree with, or you would think that he would agree with. He's doing all these programs for rehabilitating offenders instead of going to prison and doing good work. But when if people scratch a car or break someone's kid's toy or whatever it is, or hurts them, you would have thought that the logical law would be they had to make amends. If someone rips your shirt, then you have to buy you a shirt or the same shirt, or if it's very difficult, extremely rare shirt, then
Maybe they have to, maybe that's the thing. Maybe they have to go and find out who made it and see if they can get another one made, or even go and sew one, make them do some hard labour or skilled work, make them a new shirt or repair it or something like that. Fix the car. This is the thing. All with they do that with the graffiti removal and all those things under the Town and Country Planning Act. They send you a letter to say, remove it or take it off or correct it. That's, you're getting into it then. But that's why it's not criminal. It's not criminal offence. It's fines. This is when the police aren't the council and the council aren't the police. This is why you get Bristol Council, telling Dr. Tess Lowry to take a banner down from the M32 when it's under Parliament jurisdiction, and signs over motorways aren't dangerous because the council allow illuminated signs over motorways, so it can't be dangerous. But the council's not the police, right? Now the council know the Town and Country Planning Act. It's not criminal. So what the council do is they send a letter and they say take it down, and if she doesn't, then they will threaten to fine her, right? But they're not prosecuting her because it's not criminal. But that's the law that deals with it. But when Extinction Rebellion turn up, the police say, oh, this is a crime, we're going to prosecute you for criminal damage, right? But they, similarly, don't know the council's procedure, which is civil, so issue them a letter and tell them to remove it or take it off. Now, what's happening with the police and the local council is the police don't really know the local council law because they've been taught criminal damage. The council aren't police and they don't prosecute for criminal damage. They use the removal law. But neither the police nor the council in Bristol are acknowledging Parliament jurisdiction and privileges, and the Town and Country Planning Act does provide for that in detail. Class F, anything done in connection with Parliament and standing orders of Parliament using enactment of law. There's more detailed information there and not needing consent or authority. Now, the council know the act and they're using it and they're sending letters out and asking people to remove it and not fining them. They're not charging them with a crime or ringing the police, but they don't know the act well enough because they don't know the actual enactment which you apply is the right to petition, which you can be prosecuted. And that's the part that the council don't know because they don't need to use it because they've got authority themselves as the council to do what they want when they put things up. And they aren't Parliament. And this is when this orange pack comes in here, obscuring ancient laws, which is actually provided for in modern law. It's not that ancient and obscure. But the council themselves don't need to use it, and they're not bothered about it, but they should learn it and know it, because that's the act which is a lot more clear and thorough and explicit in its explanations about it. The police, when they use the Criminal Damage Act, are unfortunately misidentifying many things which are defacement and under the council's jurisdiction under civil law, and they want to bring criminal charges, but they can't. And in fact, the Criminal Damage Act has got the right privilege or interest that we not be construed against the defence against the charge. If you're exercising a right privilege or interest, which means that there cannot be a charge in that court, and you're not answerable to a plea if you're claiming privileges. And it's got it. It says it's got privileges in the act, but the police don't know what the privileges are because they aren't taught it. The council don't know what the privileges are because they're taught, even though they know the act and they use the act instead of criminal damage. So it's like Larry Moore and Curly. It's like the Three Stooges. It's all there in writing. Someone knows about it. Someone knows what it is. Someone wrote the law and made it explicitly clear, right? Which are the ministers. So why are they saying, there's maybe some obscuring ancient law there? Well, I think that Parliament have written that Town and Country Planning Act with the use of an enactment so they can use parliamentary privileges and they can put up signs when they want, even though we're eligible to do it. And I think that they've continued to make the law compatible
in certain things to facilitate for, these things that they claim to be obscure or ancient. But they've actually, some of the legislation and law, like the legally privileged items information in the criminal procedure rules. In the criminal procedure rules, the legally privileged information and items is correct for Parliament jurisdiction and privileges or any other use of it. But that's one of them, and it's correct and right. So either we've got some MPs who are honest, and some who aren't, and some who know what they're doing, and some who don't. But if the ones who do know what they're doing and they're honest, why aren't they calling out them on these ridiculous mistakes, like with the oath and deals for justice, and with, not even acknowledging rights and stuff, and also with the Town and Country Planning Act? We're not really getting much help. Tess Lowry had her petition debated. She turned up. She was sat there in the session. Now, when Bristol Council sent her a letter to say, take your banner down, why wasn't she, telephoning, the MPs who were on the petitions committee to get a letter or notice or a certificate from the Speaker? She got 100,000 signatures. She didn't know to do that. But, I mean, I don't know if she told them or not. She should have. With this Stop ULEZ one, I mean, what's the Mark? What's he called? Not Shambo, Mombo. I'm just trying to think of the MP's name now. He was also in the Stop ULEZ petition debate as well. I think it's like a French name, Mark Shambo or something. But anyway, say for example, this Theresa Villiers, she's not an MP now, but Theresa Villiers had held quite high positions in government. She'd held multiple, I think, Secretary of State positions and so forth. She even participated in an organised protest and, got a debate. If any of those Stop ULEZ people have got banners up, why didn't she sort out their certificate with the council and say it's under Parliament jurisdiction? Banners are not dangerous over motorways. Advertisements are not dangerous over motorways because they have them. They're done. It's the norm. The council are doing them themselves. So it's a lack of intelligence on some people and a lack of acting. And even if a certain person does the right procedure and process and applies for something correctly or gives the right statement, if the other responding party doesn't know it or understand it, you're in trouble, and this is, the problem we're in. But there's some really, really serious things here, very, very high up. How can you not deal with this thing as an entire problem, as an entire case? It's institutional. I think it's institutional corruption. It's corrupt because there's now multiple examples. There's multiple things where it's been set up intentionally contradictory. They're attempting to try and change things that can't be changed, and they're doing it in a way that's really terrible because they're even blatantly. It's like, when you're speaking the oath and saying it, it's actually there. You're saying it, I won't do any deals for justice, but then you go do deals for justice. You can't be that stupid to not know what you're saying and what it means. And the same thing with, Mogg, doing his entertainment on TV. You can't be that stupid. You can't. But these people have got people in front of them in the courtroom. We're meant to be bad people. You can't, you go into a supermarket and, say, I paid for the peas and then walk out without paying for them. It's like, you go into a supermarket and then, go up to the machine and not pay and then walk out and say, I paid. No, you didn't. It says, don't
don't walk out the supermarket without paying, and then walk out the supermarket without paying. Don't do any deals for justice, but you're doing it. But he's saying, I won't, I won't go and rob the bank, but then goes and robs it, I won't, headbutt someone and then go headbutt them. I won't do any deals for justice, and then he does it. I'll do your deal. This is the thing. It really is a lost cause. This is going to be really high up though in government, in responsible positions of mature adults. It's slightly overlooking. I'll have to copy this whole text out. I don't really want to have to write this video down in writing to what I've said, because there's too much writing to do. But I'll put this. This piece here covers primarily the dilemma that Extinction Rebellion and Just Stop Oil are in is set out here, right? Which is there's all these technical legal arguments around protesting, but they're not supposed to be prosecuted. But everyone is doing it that way when there's some ancient obscure law that's meant to be in effect. And even then, it's a matter of church state law anyway. It's all here. And then you've got these, this touches upon a lot of different issues that I've been raising. It touches upon the difference between felony and misdemeanor, between the court of record and the jury, these police chiefs giving pleas out. This has got everything there. They know these things are on the menu. These things are on the menu for discussion here and all inclusive, and there's issues with a lot of them. And I think they know. Maybe they're in a similar position within the Lords. Maybe there are different laws opposed to what's going on. I don't necessarily agree with it. But they're meant to vote on these. They're the ones who are meant to vote for it. Now, fair enough, if at the time so many voted for and so many voted against, and what are the against people going to do? Lords use words like the right honourable gentleman and, if it may please Her Majesty. Lords don't handcuff themselves to cars or to tanks, although some of them have started coming out and doing protests now. What do the other lords do if they get the privileges taken away and they don't necessarily agree with it? Did they all agree with it? Where's the votes are meant to be published? I mean, can we look at that 1948 Act and see what lords voted in favour or against? Can we look at the 1967 Criminal Law Act and look at what lords voted in favour or against? This is the thing. And did they vote against their will? Were they coerced into it by, terrorism or threatening behaviour or, incidents happening, like Boris Johnson's next door neighbour and blowing his head off with a shotgun mysteriously, or this Southport accident now, or explosive cars going off, or all these factors, are they under pressure? But they're the ones who are voting on these things through. And, if they're the minority and they know they're being cheated, I mean, what can we do? When I go to a court and I say I've got a ancient right and privilege in use, and the judge says I'm delusional, and now I find that far from that. It's what can you do? And I think this is where we are. But when a lot of people are concerned about all these things, and they've got voices now, and they're making videos and talking about it, but some of them are getting it wrong as well, and they're misleading. Maybe that's how this whole thing is rolling out, that lots of people are getting the wrong idea, I don't understand it, and there's so much misinformation. But then there's freedom of speech. But it's not helping that the officials, the people who are meant to be in charge, are the ones who are misleading people. But do they really not know? Are they lying, or are they like rebels? Are they like activists against the Constitution or against whatever, against truth? And this is the thing with Starmer and Blair. Are they Fabians, or are they just dumb? Or are they going along being coerced? Her Majesty, would have preferred if, the Right Honourable Tony Blair did this, then it would please Her Majesty if he would, bring in deals for justice and set the justices against their oath. Would it please Her Majesty if Tony Blair did that and he would be knighted and, made a statesman and be all powerful? This is the thing. Are they selling us out to our rights? And, some of these people used to be put in the Tower of London, even though they had privilege of peers, they would put them in the Tower of London. Lord Hanningfield got prosecuted and went to prison, but it seems that they've taken away all these rights and privileges of the peers supposedly claimed to have done, so they can be prosecuted, but now they aren't getting done. It's like they've pretended to take away the protection, but all they do is just can now deny liability and fault, and they by lying deniability and fault and never having to stand for the crime, they've got more protection and they don't need the right, and in a way, the more and more the government refuse to openly admit the truth and their errors and conceal or connive to hide it or try and resolve it in some other way, which seems to be the tradition now, or modern tradition, and people just standing down, it's making it worse. It's what's happened is they claim they've reduced and removed all these immunities and privileges except a basic parliamentary privilege, yet they're to open up people like Lord Hanningfield, so if they want to smack his bottom and punish him, they can do it and make an example of him. But what's really happening is, even though in law and on paper they claim to have opened up so they can be accountable and go to prison, none of them are doing. Like Jimmy Savile, they're not actually. Well, actually, was it Alex Ferguson or whatever was on the motorway and he got prosecuted for speeding, Alex Ferguson, things like that. But that's like a police chief's joke or a government joke dicking around with the motorway traffic when he needs to go to a football match. And I think that was a setup. They can toy with them. They've made them open to be punished at even the very lowest levels, right? And they can now be kind of like toyed with like pawns. If they don't do the bidding of their masters, they've got no protection. But when it's actually something really, really serious, like very serious, they're just lying. So they pretend that nothing exists, no crime, no fault, nothing exists. And I think that's one of the major things with the burning of Parliament and all of the petitions with the complaints and grievances going up in flames. Keir Starmer now with his anti-Semitism, assisted suicide, which is, against the sixth commandment of God in the Jewish commandments, which is quite a serious thing to impact the Jewish religion, as well as, Sunday's a day of rest. But, that's quite serious, really, for the Jewish religion, and they say that kill humans. And all they're doing is standing down. They're not actually getting put in the Tower of London or in prison, or even acknowledge that these serious crimes happened. They're just kind of, we'll have to correct it and do something about it on the hush. Why remove the protections? Because what actually the real truth is that they've removed all the protections and privileges because they don't need them, because now they're just protecting themselves by lying, because it's such a shame and embarrassment, if not an outrage to the public, that it could even happen or be true, that they're just absolutely in utter ignorance and contempt and blanking it, that to acknowledge it, which that is more potent protection than actual inact of law or a legal thing, because then at least everyone could say, oh, Keir Starmer's anti-Semitic, right? More so than Corbyn. Or they could say, Tony Blair set up the legislation against the judges' oaths. This is an outrage. At least then people know they've done it, but he can't be prosecuted because he's got privileges or immunity. And this is the thing. At least that people get angry then and kick off, but the law protects them. But people know about it now. What they've been trying to do is they removed all the privileges so they could actually punish each other and keep the other peers under, whip them basically. They opened up the whip for their own kind so they can whip Alex Ferguson if he's driving down the motorway. If any of them, deviates from the plan, they wanted to be able to punish them if they deviated from their own master plan. Now we can punish our own people if they don't abide by the master plan rather than being protected, right? But instead, it's silence. That's the title of Tommy Robinson's film, Silence, isn't it? So they don't even want it to exist because they know that if it exists, then there'll be public outrage and then, people will change their voting. So now it's just absolute ignorance and censorship and ignorance of the crimes. If you've got censorship and ignorance of crimes in positions of power and the police are going to also ignore it as well, you don't need any law or privileges because it's peer protection. It's actually peer protection, and it's not peer protection written in law. It's not peer protection enacted in law, in writing and given assent. It's actually real human creature, spiritual soul, living organism, peer protection. These political party people just won't dob each other in. They won't take action against each other. It's like the Get Along Gang, the Tufty Club, and because they're all either in red or blue, Labour or Tory, they're all like, none of this big pile of complaints that's come in the post doesn't exist, and they're the ones who are, they cannot make it official that these complaints could possibly exist or be correct, except one or two, like, post office scandals and all these things, where really get pushed through, or they like pick and choose some of them, that they can allow because, it's okay, we're going to have to, so-and-so's going to have to take the rap for this eventually, but it depends, who you are and who you know, and if it can be used as a political tool. If Alex Ferguson on the motorway giving speeding fine who's going to the toilet can be used as a political tool, then, now we can prosecute him. And there was also something that I found out about. They also claiming that it answered one of my questions that knights and dames actually were at one point in more recent law treated as if they were peers. So they were treated as if they were life peers. I don't know if it extended to justices, judges, and that might have, because actually what I've found out through these privileges is the complainant, the person who raises the complaint, and the ones who sign their oath to it, really, they are meant to be the ones who are protected to pursue the cause, right, under that jurisdiction. But the solicitors and the attorneys aren't actually protected. Like if they commit corruption or fraud or whatever, they weren't actually meant to be protected, the attorneys and lawyers. That's important and interesting. So they haven't actually got any immunities. It's the person who raises the complaint and the witnesses, really. And when you petition in Parliament, I suppose all the petitioners, but I don't think their attorneys qualified for that under Magna Carta. But what I found out is that also, like, the knights and dames at one point were regarded as life peers in law for privileges, but not after that 1948 Act. They took it away from all of them, which might have answered one of my questions, is when the peers could only be prosecuted by their equals, how did they treat the assizes judges? Could the assizes judges prosecute them, or did it have to be another Earl, Baron, Lord, or whatever who was a judge? Well, according to that, it could have had something to do with if a knight like Sir Walter Raleigh could have prosecuted Baron Denman, for example, just like for, that might have made it possible if they were regarded as peer privilege. That means that not women, but a knight or maybe the justices could therefore, because they were justices, prosecute it. But I don't think that was the case under Magna Carta. I think it definitely actually had to be the other actual barons and lords, if they were justices or not. But I think they did actually, at one point, they did make it so it was a knight qualified as a peer, and that means that I think a judge as well, so that they could have been heard by the assizes and so forth. I think that's how they were doing it for a certain period of history, which might calculate correct to some of those petitions that we've got from the Petitions Committee, but I might be wrong about that. But I know they scrapped that in 1948, after 1948, but they were claiming that there was no peerage privilege after 1948, only parliamentary privilege. But it would explain something to do with, at least after 1215, the 1300s, 1400s, 1500s, when you get into the maybe through the 1600s, 1700s, or 1800s, I think that would solve the question that I've been asking myself in my mind of how can they be in front of the assizes, which they are in some of those petitions, either for civil or criminal, but not after 1948. But it would answer my question. It's looking like that might be the answer to the question that I had. But I'm not saying that that's right or wrong yet, but that's something that I'm making note of it now to myself, and something that, if anyone else wants to look into it, that's part of this whole thing. But this video has pretty much covered everything that I can think of now. What this, I can't read all it. I can't do all this by myself and read all this. It'll take forever, and I ain't got any money to pay a lawyer to do it. And no, I don't think I don't even think Elon Musk could afford to get a lawyer to do everything that I've said in this video. I think Donald Trump would be pushing to get someone to do it, because you need, I mean, look at that case. It was 100,000. Well, Donald Trump spends millions on lawyers, but saying that, Stonehenge Alliance of £135,000 with 8 bundles of law. 8 bundles of law, £135,000 over 3 days in the civil court, and they didn't win. But at least they did the work. The lawyers did the work, and they did the research, and they put the bundles together, and they submitted it to the court, and they presented whatever needed to be talked about, and the rest of it just looked at. This is what I'm doing with this video. I don't know if this is 3 days worth of court sessions, pointing out the points that need to be looked at, but this would take. I mean, I don't know what cases Donald Trump has, but when he's just been prosecuted for a crime, an offence, I don't know how they're spending millions on these cases. Don't seem right to me. £135,000 and 8 bundles on defending Donald Trump on even American privilege, but not millions, because I don't think that there's. I mean, the amount of material that I've got on privilege now, I know there's quite a lot out there, but I reckon it's probably only about as much as 8 bundles worth to revise and review. There's only about 8 bundles worth, I would have thought, once I get the things that I want to get together, for privileges at least anyway. So £135,000 worth of casework there. It's not millions, but all of the matters I've discussed in this video aren't just privilege. There are lots of extensive other matters. And these are matters of church state or law. These are matters which no citizen should ever have to produce the money to get these matters dealt with. Ever. None. Because that is not a crime you've committed yourself. These are crimes of the state, crimes of the government, crimes of the country, crimes of judges, crimes of Tony Blair, crimes of... This is like the Attorney General. This is the point of the Attorney General, really, or one of them. or even the Lady Chief Justice. But if they're involved in it, who can save you? You're not meant to. This is what the signatures are meant to do. The weight of the public signatures, because a signature's free, right? If you're poor and you've got no money, you should never have to pay £135,000, let alone £1 million for these issues to be resolved. But it doesn't. Well, if you're poor, you can walk down the street, and collect signatures. It's almost like, and those weight of signatures are meant to compel the government to act, which is why 100,000 signatures is meant to compel them. Although nowadays you can share it for free. If you're on Facebook, it's still not easy to do because Mark Zuckerberg's got loads of caps on how many messages you can send, which, and there's loads of obstructions from administrators when it's matters of public meeting acts, is that it's unlawful for them to stop you transacting evidence. You should be able to collect 100,000 signatures and compel the government without having to pay any money, like nowhere near that amount of money, like buy a pen and paper or, do a bit of sharing or advertising. That's meant to, those 100,000 signatures are meant to be worth priceless. There's not meant to be an amount of money on them that you could buy, because it's the will of people. Politically saying do this in the way of souls, of spirit, of will. It's meant to be, to compel the Attorney General to act more than, any amount of money that could pay for lawyers to do 8 bundles worth of law, This is it. That's the point in getting the signatures and the petition. And the thing with some of these things, it's actually a crime. If they don't resolve it, it's an offence. If they don't give a resolution, it's further crime committed. They're actually committing crimes. And the courts are there to protect us from crime, and the police. But the police aren't even acting. The fraud police, if there's a fraud, the Speaker of the Houses of Parliament is committing fraud, but the police can't get the Speaker of the Houses of Parliament if he's committing fraud on his opening of Parliament with his ancient rights and privileges, if he's fraudulently issuing that, because it's privilege of Parliament. So we have to petition Parliament for it. You got your Sergeant at Arms and so forth, but we're meant to compel them. But then again, it's a breach of privilege, but they decide whether it's a breach of privilege, like in Lord Hanningfield. Erskine May tells us that fraud or corruption is a breach of privilege, so we know that it definitely is. They don't decide what is and what isn't a breach of privilege when we're given definitions of what is and what isn't in law, like fraud is. So we know that if there's evidence that they've committed fraud, we know that that is or would be a breach of the privilege if we can prove it. And if you put, at what point, if they continue to ignore it and deny it, and then therefore committing more and more crimes, at what point, who compels them? Who compels them? And this is the thing, we elect them. Well, they might have the privilege, put it this way, they might have the privilege of Parliament, and the police might not be able to arrest them, even if we know that it's looking like it's a breach, and it's defined as a breach, and they don't have the privilege of defining it as a breach when it's defined for us. What we can do is not elect them. We can elect them, or we can report them to the forfeiture committee, or we can just not vote them back in again. And that is the reason why I think they don't want to admit it, because we won't vote them in. And that's why it doesn't matter if you take away their privileges and take away their rights, you're still voting them in. And if they just lie and don't have to admit that, occasionally they step down like Boris Johnson, but that it's the knowledge, it's the information, it's the truth. And they won't be elected. It's political suicide to admit faults of this magnitude. No one will turn up at the next election. It will either be like on Parliament, or with the level of the outrage, with the level of the crimes, the next time there's an election, no one will turn up to vote. And then who's going to be in charge? Let alone for proroguing Parliament. I think that's it. We can.
The people have to do it, not the police. And the people really, once they're aware of this, even if the MPs don't admit it, which if they admit it, it definitely is political suicide for themselves in their career and their ability to be able to make laws and be there and run the government, which is why they won't admit it. The other part is that we don't really need them to admit it if everyone can raise awareness, and then we just don't turn up and don't vote. And that's never been a crime to not vote. You don't have to vote. You know, and the army or police can't arrest you for telling people not to vote. And I think that is what it comes down to. If people want to handcuff themselves to tanks or put paint on things and claim it's in the parliamentary privilege, there is that. It exists in law, but they're not giving us it. They're not granting us it. But they're also not admitting their own crimes when they do something wrong. I actually think that, you know, Extinction Rebellion, to save the current dilemma they're in, everyone should be just, say don't vote, because the police can't arrest you for saying don't vote. It's not a crime to not vote. You have to boycott voting. There's no legal obligation to vote, and if they want to try and stop us using messenger or mail or telephone to say don't vote, the Public Meeting Act, we aren't breaking any law. You aren't breaking any law by doing that, and the Public Meeting Act protects you to transact the information and attend to do it. So the Public Meeting Act actually protects you, even without privileges of Parliament, to say don't vote and to tell each other why not to vote. And I think that's really why Kamala Harris and they're trying to take these channels down or drop their statistics, and not, because they don't want the truth. But there's a lot of people who are confused, who don't know exactly what the truth is or getting it wrong, like this. So it's clarification, but you've got a case, you've got evidence, you've got a complaint that protects you, right? Definitely under witness protection. So you got a serious cause or complaint that you're trying to get. All you can do is, what can you do other than try and tell people and get them to realise. But the more and more they get it wrong, the more and more people are going to go into prison wrongly, like this here. I think more effort could be made to tell people not to vote and tell people the truth of these crimes that have been committed, and people realise it, than the effort that goes into damaging or breaking anything, which can be argued under privileges and under ancient rights. But all the time they're telling people that it's not, and trying to put it under the basis of normal protesting. So there's a few things in this. I've covered quite a lot, but the whole thing's important. The whole thing to do with the jurisdiction of the courts, the police with the taking confessions and pleas for driving licenses, the privileges of the peers, the definitions between all the rights, the whole thing really. So I guess I'm going to have to share this page.